In February 1876, two attorneys walked into the same government office in Washington, D.C., carrying paperwork for the same kind of machine. Only one of those filings would go on to change how the world talks. On February 14, 1876, an attorney for Alexander Graham Bell filed a full patent application at the U.S. Patent Office for a device to transmit vocal sound electrically. That same day, a different attorney filed a competing document for another inventor, Elisha Gray, describing a different mechanism for the same job. That second document wasn't a patent application, it was a caveat, a formal notice telling the patent office, "I'm actively working on this," without asking for a patent yet. 19th century inventors used caveats to stake a claim on a half-finished idea while refining it, and that legal distinction matters enormously for what happened next. Both documents landed at the same office on the same day, but not the same moment. Bell's application was logged earlier in the receiving sequence than Gray's caveat, one administrative detail that turned out to matter more than almost anything either man actually built. Elisha Gray was no amateur chasing a lucky guess. This comes from a single biographical source in our research, though Gray's patent record is a matter of public record. By 1876, he already held the first of more than 70 patents he'd eventually accumulate, and had co-founded the company that became Western Electric, serious, established work, not a hobbyist's hunch. So what did Bell actually file that day, in his own words? This description comes directly from the patent text itself, though we're relying on a single source for the exact technical language. Bell's application describes transmitting vocal sound electrically by producing electrical undulations shaped like the sound's own vibrations, a fluctuating current sent down a wire to a receiver that reproduces it as sound again. It's strikingly modern for 1876, not just switching electricity on and off, but shaping a signal to mirror an actual sound wave. 3 weeks later, on March 7, 1876, the Patent Office formally granted Bell's application as U.S. Patent number 174,465, titled simply Improvement in Telegraphy, later called one of the most valuable patents ever issued. But was that grant entirely clean? For more than a century, one narrower question, not whether Bell filed first, but whether his final application was influenced by something he shouldn't have seen, has split historians into two camps. Historians disagree on this point. Some argue improper access to Gray's caveat shaped Bell's final application, while a 2020 peer-reviewed study found no documentary evidence of that and traced Bell's own ideas to an earlier date. At issue, a passage on variable resistance, similar to Gray's caveat, was written into the margin of Bell's application rather than the main text. Historians Evenson and Schulman argue this shows Bell's team saw Gray's caveat first. But a 2020 study in the Proceedings of the IEEE by Benjamin Lathrop, Brown reached the opposite conclusion. A January 25, 1876 note from a Bell associate mentioned no telephone specification like Gray's, and a dated sketch shows Bell's own drawing predating Gray's by more than 40 days. This is based on a single source in our research. The absence of documented contact isn't the same as certainty they never crossed paths professionally. There's no direct evidence Bell and Gray were personally aware of each other's telephone work before that February day, even though both moved in the same small world of telegraph engineering. Gray's own path ended differently. His caveat never became a granted patent, and no source describes his liquid-based transmitter ever working as a telephone. Once he learned Bell's application was recorded first, Gray abandoned his claim, and when the dispute later reached the courts, they sustained Bell's patent. So depending on which historian you trust, this is either a story about an ordinary coincidence or a much narrower, still contested question about one margin note on one afternoon. That single margin note carries real weight. An established rival filing the same day, a sequence decided by administrative bookkeeping, and a disputed note still argued over using primary letters and drawings. This isn't a story about one inspired person with an idea nobody else had. It's a race between two credentialed competitors, where the paperwork decided whose name survived. What isn't in dispute is the paper trail. 2 filings, 1 office, 1 day, and a ledger that logged one of them first. Everything else, who saw what and when, is still argued over, a century and a half later, from the same handful of surviving letters and drawings. For the 2 men standing in that office on February 14, 1876, it was the entire story.